Okay, well, thank you, Larry, and good morning, everyone. My name is Marty Rabinovitch, and my topic this morning is called No More Age Discrimination in Employee Benefit Plans, and we will look at a decision called Talos and Grand Erie District School Board, which was a case decided by the Human Rights Tribunal of Ontario. So we'll start with a little bit of background information. So in 2006, Ontario effectively ended mandatory retirement by enacting a statute called Bill 211. And part of Bill 211 was an amendment to the Human Rights Code, which essentially permitted employers to differentiate between workers who were under the age of 65 and those over the age of 65 with respect to workplace group benefits coverage. So this section at the time was seen as a compromise to protect the viability of workplace benefits coverage as benefits used by employees increased with age. The cessation of benefits typically mirrored the availability of private pension and retirement benefits, as well as government benefits to which employees would be entitled once they turned 65. And it therefore became fairly common for employers to have benefit plans in which the coverage simply ended once the employees turned 65. So let's meet Mr. Talos. So Mr. Talos was a teacher. He turned 65 years old, and he was an employee who had one of these typical benefit plans, which provided that coverage would end once he turned 65. So as a result, he lost all sorts of benefits, including health, dental, and life insurance, despite the fact that he was still working full-time. Unfortunately, his family was not in a very good position financially, and his wife, sadly, was terminally ill. So let's meet his wife, Diane Talos. At the time, she was under 65 and did not have access to any private benefits or any government benefits. She was suffering from stage 4 cancer. She was relying on the Trillium drug benefit, but unfortunately many of the drugs that she needed were not covered because of her diagnosis, and as a result she simply could not afford these medications and wasn't able to use them. So she had access to these medications through her husband's benefit plan at the school board, but now she didn't. So as a result of all of this, the couple had sustained all sorts of actual losses. Some of them include peace of mind, deductibles in the amount of $3,000, so they were eventually able to apply for and get certain government benefits, but there were deductibles of $3,000 there. They were subjected to a needs-tested process to obtain insurance. The benefits that they were able to get certainly was not a comprehensive replacement for the benefits that Mr. Talos had through the school board. And again, they were relying pretty heavily on this Trillium drug benefit, which is it's a provincial benefit essentially for lower income individuals and those who were spending a significant proportion of their income on these very, very expensive drugs. So, Mr. Talos starts an action at the Human Rights Tribunal. The allegation is that his employer has discriminated against him on the basis of age, contrary to the Human Rights Code. So there is a 2013 interim decision of the tribunal, which we will talk about first. So on this slide, we have an excerpt from section 25 of the code, and the key here is the section at the bottom, section 2.1, and this again is under the Human Rights Code, which says that an employer essentially can discriminate based on age with respect to benefit plans as long as what they are doing is in compliance with the Employment Standards Act. So let's take a look at what the Employment Standards Act says. Okay, now when you first start looking at it, the Employment Standards Act seems to quite clearly prohibit against benefit plan discrimination on the basis of age, but then when we dig deeper and we look at the relevant regulation, we see that age is defined as any age of 18 years or more and less than 65 years. So if you're between 18 and 64, well then you can't be discriminated against based on age. But when you turn 65, well, now you're not protected anymore based on the plain wording of the legislation. So for this interim decision, the issue was really whether or not the claim had a reasonable prospect of success. The adjudicator at the Human Rights Tribunal went through the statutory analysis that we just went through and said, well, no, a plain reading of the relevant legislation says that what this school board is doing is allowed, because once you turn 65, there's no longer any protection. So as a result, the claim was found to have no reasonable prospect of success. However, there was another part of the claim that was allowed to proceed, and that was a constitutional challenge. So the claim for discrimination under the code was dismissed, as we just said, but the adjudicator determined that the constitutional challenge of the legislation itself may have a reasonable prospect of success. So constitutional legislation is the supreme law of the land. It includes the Constitution, it includes the Canadian Charter of Rights and Freedoms. So any law that's enacted by the government, whether it's a federal government, a provincial government, or a municipal government, must be compliant with the Constitution. And if it's not, then it's going to have no force or effect. So here, the relevant provision of the Canadian Charter of Rights and Freedoms is the one about equality rights, and that's section 15. So what it says is that everyone's entitled to equal treatment, and they cannot be discriminated against due to a whole bunch of factors. It's very similar to what's in the Ontario Human Rights Code. The key one here, though, is age. Okay, so this was the question that the Human Rights Tribunal now had to deal with in 2018. And so the tribunal goes through the analysis for section 15 of the charter, and they do find in favor of Mr. Talos. They find that he did experience disadvantage on the basis of age, contrary to section 15 sub 1 of the charter, because of this section 25 sub 2.1 of the Human Rights Code. So in other words, depriving him of his benefits just because he turned 65 was discriminatory, it was unconstitutional, and therefore, it didn't apply. Okay? The court went through a number of points of analysis when dealing with this particular case. I'm just going to highlight a few of them. So first of all, the tribunal found that allowing for different benefits past age 65 makes elderly workers vulnerable to not being rewarded equally for the work they perform. And they provided the same labor that they did at age 64. So if everything else is the same, it's not fair to deprive someone of their benefits just because one day they're 64 and the next day they're 65. Okay? What was very important for the tribunal as well was the actuarial evidence. So in very, very simple terms, how much does it actually cost to continue these benefits? And contrary to popular belief, I guess, the evidence in this case was really that the cost of continuing health care benefits for employees who were 65 or older was negligible, so maybe a bit more, but not all that much. The evidence was that for dental care, there was going to be no increases generally. Life insurance would increase a little bit, but the actuary who testified was of the view that those effects could be mitigated. Further, the tribunal was very clear that retirement should be based on individual financial considerations and not age, and that removing these benefits could effectively force someone into retirement when they frankly weren't ready for it, and there was no other reason why they would need to do so. There were also a bunch of arguments that were made and rejected. I will leave that to you to take a look at. Okay? So in terms of alternatives here, essentially really what this is coming down to is that the tribunal says, look, if there actually is actuarial evidence that the cost of providing these benefits to employees once they hit 65 is so high, to the point that it's going to be, totally, unfeasible for them to offer these benefits, then they would likely consider that to be a bona fide or a good faith reason for not offering those benefits. Interestingly, the actuarial evidence at this particular hearing said that it wasn't really until the employee turned 79 until the benefits would actually really start being financially problematic. Okay, so where does this all leave us here? So the first question to consider is, are we entering a new era of workplace benefit plans if this case is not overturned? The answer is probably yes, although again, if there is a case that comes about in the future in which the actuarial evidence suggests that providing some of these benefits is going to be cost prohibitive, that might change the result. The other point to think about too is that the Human Rights Tribunal did find this particular statutory scheme to be unconstitutional, but the Human Rights Tribunal doesn't actually have jurisdiction to strike out the law for everyone. What they do have the jurisdiction to do, though, is to say, well, we're not going to apply it in this particular case. So technically, this decision really only applies to Mr. Talos, his wife, I guess. But presumably, if a similar case were to come along with similar facts and similar evidence, unless the tribunal's view on the matter is going to shift overnight, then we would expect that the result would be the same. In terms of what employers should take from this and what employers should do, it may very well be prudent for employers right now to take a look at their benefit plan offerings for employees, and in particular to look at whether coverage is going to automatically be revoked for certain benefits for employees. And if that's the case, at the very least, start exploring other options, either with the same insurer or different insurer, to see what the cost of providing those benefits to employees once they turn 65 will be. Okay, and as a final note, in this particular case, the decision did explicitly state that it was only dealing with group benefits and not long-term disability pension plans and superannuation funds, which I understand are very, very similar to pension funds. But in any case, the same reasoning still might apply to those sorts of benefits in the future. So employers should be proactive and start exploring what the other benefit options would be for their employees. All right, well, thank you very much for listening. That concludes my presentation. And I would now like to introduce my colleague, Sarah, who will be talking about increased general damages awards at the Human Rights Tribunal in the Me Too era. Thank you.